I got here yesterday and I, can feel the enthusiasm for Bitcoin and what's happening here. And when you start to put lawyers on panels, it's like brakes in a car. But I think it's a couple of things I wanted to just have everyone keep in mind. Just by its very nature, Bitcoin is going to get a lot of scrutiny. The reasons you guys are all attracted to it also makes law enforcement wary. And I think it is really a question of if there's going to be criminal prosecutions, but a matter of when. And I think this last week, with what happened with the seizure warrants, I don't have any personal involvement in any aspect of that, but I think that's a very telling sign. And just for those of you who don't know, Mt. Gox has this U.S. subsidiary, Wallet. Not the wallet, sorry. They used a wallet to run through their subsidiary. There were seizures of a bank account at Wells Fargo and Mt. Gox's wallet account. And what that means is an agent from a federal agency filed an affidavit in court, which is judge signed, for both those accounts, and they were seized. And to seize an account like that, you have to have probable cause that there's criminal proceeds or that a crime was committed. So that's serious business. Those aren't just done lightly, or when I was a federal prosecutor, there's actually usually a federal prosecutor working with that agent. So it's not just an agent on his own or her own doing this. I think it'd be very realistic to expect federal prosecutions there. And I think if you look at what actually the basis for those warrants were, it was lying on bank forms. So for example, the head of Mt. Gox, and I don't remember his name, and everyone else here probably knows it except me, didn't sign and check the box that they were a money transmitter business, essentially, an exchange. You can't lie on bank forms. That's a federal crime. It's a pretty easy one to prove too, because you got the bank form and you can show what they did, and that's it. So I think that's something to keep in mind. That doesn't mean it should deter what's happening here, but it's just something everyone should keep in mind.
That's a good question, Mike.
Yeah.
How do you answer that question if you don't know on a bank? I mean, so you get asked, you're in this one of these great, you feel like we're telling you here that you might be a money transmitter.
I think the way I would do it, I would go with my lawyer to the bank, write a letter, explain my position, why I'm checking that box. You're operating in good faith. And I think one thing to keep in mind is you can hire all the lawyers in the world to think that's going to protect you, but if you're not honest with them, and you're not telling them everything you're doing, that's not a legal defense later down the road. You can't say, oh, well, I had lawyers do this. There's a defense called advice of counsel, and for that defense to work, you have to be fully forthright with your attorneys. So you can't just hide behind attorneys. So hiring Ryan and Dax and all these law firms, he's got a ton. 7. It's very important. I'm sure Trade Hill is like this. They're telling their lawyers everything. And that's really important. So not to scare anybody again, but it's important to operate in good faith and be honest. And the last thing I would say, is what do you do if you get a call from a regulator, Vincent, or even the state regulator? What does that mean? Is there potential criminal implications? And sort of the answer to that question, the answer to it is potentially always yes. When I was a federal prosecutor, I worked mostly with the IRS and FBI agents to prosecute financial crimes. But a lot of the cases we built were first investigated and built by other agencies, and then they would hand over the evidence to us. So it's not just a knock on your door from the FBI that you should worry about and think about. It's when anyone's asking you questions from a government agency. It's probably wise to consult with an attorney. I'm not just saying that because I am an attorney, but just to keep that in mind. And I think the main thing to keep in mind is, and what Clair and Ryan are doing is they're doing everything they can to the best of their ability to comply with the law. Every lawyer is going to tell you you need to comply with the law. How to comply with that is sometimes difficult. But if you're operating in good faith, you're working with lawyers, you're transparent, that's all showing that you're not trying to commit a crime. And I think the worry from law enforcement, if I were still a federal prosecutor, prosecutor would be Bitcoin's being used by drug lords, it's being used to launder money, it's being used by terrorist organizations, and we can't trace this, we can't follow this, we're suspicious. And so I think when you're under that level of scrutiny, you need to be really, really careful.
What do you think? I was going to say, there's something that Bitcoin, there's this threshold for reporting that, it's suspicious activities, right? And one question is whether a Bitcoin transaction is sort of inherently suspicious under those rules.
And I'm not an expert on that area, but I would say you better do your darndest to make sure that you're considering what the activity is and whether you think it's suspicious. I mean, obviously people use Bitcoins for plenty of legitimate reasons all the time. So I don't know that inherently it's meets that suspicious definition to file a form, but I think you really gotta there's a lot of red flags out there. If you're in compliance or you're running an exchange, you gotta be constantly thinking about it. And so that you can stay out of trouble. Because look, I'm a criminal defense attorney, but I don't like to see anybody in trouble. I mean, that's sort of counterintuitive because it doesn't pay the bills, but really no one wants to see people get in trouble. And there's no reason anybody should get in trouble if you're trying to do the right things.
It's actually the first question Clair asked when we met was, is a Bitcoin transaction inherently suspicious? How do you research that? My job.
So, can I comment a couple things? So, I think it's interesting that the Mt. Gox Dwala seizure warrant wasn't based on this FinCEN guidance of virtual currencies. If you read it, it relates to Mt. Gox, it relates to virtual currency, Bitcoin, but the bases for the seizure were not, you are an administrator or a seller of virtual currency, therefore it's money transmission. It was that, it was relying on bank forms or that there was funds, customer funds, converting Bitcoin to dollars at Mt. Gox, transferred to Mt. Gox's U.S. subsidiary, and then cashed out through Dwala. There's no suggestion, I don't think, that Dwala was doing anything illegal. It was that the subsidiary was really standing between two parties, receiving funds and paying out funds. And that's kind of the classic definition of money transmission, and that was easy to follow. I think it was just, in order to get the warrant, you just stated the low-hanging fruit. It may be that they had all sorts of other bases.
And that's right, you often in a warrant don't tell you the whole case, you just need to meet the probable cause standard. So I don't know what happened, but that gets prosecuted.
Carol has a comment.
Yeah, if I could add to that, interestingly enough, the case came out of Maryland. And probably what most of you in the room don't know is that the leading asset forfeiture expert in the country is now at the U.S. Attorney's Office in Maryland. He also, and I have worked with him over the last almost 4 years now, relating to the Eagle case. And in terms of a resolution ultimately to that case, and the actual theory that was used is that the violation, the failure to be licensed, failure to be registered, so the 1960 violation becomes the predicate offense to allow the asset seizure to occur. And that's what developed out of the Eagle case. So it's the fact that if you're not licensed and you should be licensed, you're not registered and you should be registered, that in and of itself became the basis for seizing the assets, even though, as we all know, there was probably something else going on there.
Yeah, which I think it emphasizes an important point, which is that you may not have a full answer on the state questions about whether you're a money transmitter. Again, states, it's money transmission, receiving money, purpose of transmission, or sending money, or sell of payment instruments, right? Those are complicated issues to work through on a 50-state or 48-state basis. But with the FinCEN guidance and the base of money transmission, meaning accepting any sort of value and delivering any sort of value on the other end, if that's money transmission, it's fairly easy to to conclude that you need your FinCEN registration, which might, in some instances, keep you out of the 18 U.S.C. 1960 that Carol was mentioning.